So, as the buyer and seller reach the end of this particular journey, there is two more phrases that they may not be familiar with. One is exchange of contract, and the other one is completion. So, if you could explain to the listeners what the difference between the two.
So as the transaction progresses, we do all the legal checks we need to do if we're acting for a buyer. If we're acting for a seller, we answer any questions or inquiries that are raised by the buyer's conveyancer. And then as it progresses, we would send out paperwork to sign that we then hold on file on trust for the client. So we don't do anything with that unless we speak to the client. Once everybody is ready and once the date is agreed, we then work backwards, and once all the I's are dotted and T's are crossed, we can exchange contracts. It's only when we exchange contracts that contract, if you like, becomes legally binding and everyone is, for want of a better word, locked in. So at that point, to undo a transaction becomes very expensive and problematic. However, up until that point, anybody can change their mind.
Has that ever happened to you?
Yes, yeah. I have phoned a client. We have to phone a client on the day of exchange to confirm we have their authority to exchange. There is a case law that suggests it is best practice to do that on every day. So, for example, the chain doesn't quite achieve the exchange on the day it's supposed to and it goes on to the next day, we would phone the client again for their authority. And I remember a transaction where I was doing that and they were first-time buyers, and on the second day they said they'd done some sums overnight and thought they'd be stretching themselves a little bit too much.
Wow.
So
What's the penalty?
nothing, because we hadn't exchanged contracts.
Okay. But if they had exchanged
If they had
contracts-
exchanged contracts, then but in a practical sense, that very, very rarely happens in terms of residential conveyancing. I have dealt with transactions in the commercial arena where a client has taken a commercial decision that it isn't worth pursuing, and the costs of that can be astronomical. Loose deposit, which is usually 10% of the purchase price. You can also be sort of sued for any other consequential losses, removal costs, that kind of thing. So it's quite difficult to quantify, but it's usually a decision that it isn't taken by somebody just buying and selling a house. It's usually, as I say, my experience, a commercial client who made a commercial decision based on their business needs.
So exchange of contracts, that's a phone call to the lawyers on the other side. We're good to exchange. It's as simple as that.
Yeah, we run through the contract. It is as simple as that. It becomes more complicated when there's a chain of transactions, because if you can imagine what one of the risks is that if we were to do that wrong, our client could end up with no properties if we exchanged on their sale but not their purchase, or they could end up with two properties if we exchanged on their purchase and not their sale. So there is a legal mechanism in place which involves giving a system of releases and exchanges up and down the chain. And the way that then works is that at the end of that process, everyone has exchanged contracts. So that is sometimes why it can go on to the next day, because if that release goes so far down the chain but doesn't come back up for the exchange of contracts, then it would potentially go on the next day, depending on the length of the chain.